sidewalks, in parks, plazas, and in most states, capitol grounds. Most states, capitol grounds are traditional public forums, places where people can go. They can be subject to a permit, nothing inconsistent with that. Although it's very rare for state capitol grounds to require permits. In other words, you can go, you can demonstrate, subject to time, place, and manner restrictions. What about other property? Well, government might create other property solely for the purposes of having a place for people to demonstrate, or for expressive purposes. We don't have many cases on that issue. We have one, really. And it was a case of a municipal theater. And the government and the court said in the municipal theater case that no, it's not open to anybody who wants to go in when there's a production going on. But how productions are chosen? Those productions have to be chosen in a way consistent with the First Amendment. And so, if in fact somebody wants to rent the hall to put on a production, it's first come, first served, unless the government has a compelling reason to exclude a person who wants to rent that hall. This is, of course, a business that the city is in. They're renting out the space. But with reference to people who choose to rent it, they have to act like a deli counter unless they have a very good reason for excluding. The case dealt with a municipal theater in the South where people who wanted to use it wanted to put on the musical production Hair. And if you're familiar with that musical production, there's some frontal nudity in that production, and the people in this community said, well, we can't have that. That would be terrible, and banned the production of that. And the Supreme Court said, you know, they didn't have a compelling justification to pick and choose among speakers in that situation. And then we're left with all other property. So think about it: military bases, and jails, and post offices, government office buildings, the IRS office, government weather station. Think about it. Government owns lots of stuff and lots of property, and there are going to be times in which people want to use it because it's appropriate to go there to express opposition to what government is doing. Can you do it? Probably not. Probably not. This is property that the court says can be reserved for the purposes for which it was created. So the post office was created for the postal business. Military bases are into training people for the military. They're not places where we have historically exchanged ideas. So that doesn't mean that speech cannot occur, but government has greater ability to pick and choose among speakers. It can say, you can speak, but you can't speak yet. And so long as they can defend that, having a rational basis, in other words, read that as in non-lawyer speak, a good reason for saying, you can't speak, Andrew, but you can speak, that's enough to satisfy what the Constitution requires. So that's a lot of public property which can in fact be, for all practical purposes, off limits. That doesn't mean people should try to go onto that property and try to use it, because what the law says and how it's administered are two different things. The administrator of that property may very well not have any problems, at least initially, until somebody asks questions about what he or she is doing. So, for speakers in this, my advice to speakers is, if you feel like you have to go there, don't prejudge how it's going to come out. Make efforts to get onto the property. Try to hold your demonstration if you can do that without violating any law. If you get kicked off, well, you get kicked out. And then you can analyze whether or not that's a legitimate action by government, and if it is, well, then you have to find another place. But don't give up and decide from the beginning that you, in fact, cannot use that property for speech purposes. So let's go back for a moment and to think about parks and sidewalks and state capitol grounds. In Pennsylvania, in 1991, Judge Rambo, United States District Court judge here in Harrisburg, held that the state capitol grounds are public forum. She particularly said that the rotunda is a public forum. The rotunda is a public forum. But no, merely because you say a place is a public forum, it doesn't mean that you can use it in any way that you want. So, some years ago, some of you may remember this if you lived in Harrisburg for a long time, homeless people, largely from Philadelphia, came to Harrisburg and they camped out inside the rotunda. This was pretty amazing. This was kind of chaos in the rotunda, which was simply looking very spiffy. These people have these microphones and they give important speeches. Everybody looked stressed up. And these people were homeless and they were camping. And that went on for a while, and I was one of the lawyers trying to keep them there, but it was a losing battle merely because you have a right to go into the forum, into this forum, and the rotundas we're talking about as a public forum. It doesn't mean that you can engage in any form of demonstration that you choose. Therefore, once again, now we're confronted with manner restrictions. Was this a legitimate manner restriction? Did it serve a significant governmental interest? Did it leave open other options available? And the answer ultimately, if the case had been litigated, would have been any form of said, yeah. It's really not possible to run a building like the Rotunda and have hundreds of people camped. I mean, you can't really function. And you've got sanitary issues and a lot of other kinds of issues. And obviously there were other places in Harrisburg, including outside the Rotunda, where people could hold their signs and make their views known with reference to the issues that motivated that particular demonstration. That was a demonstration really about a very inadequate response by government with reference to the plight of homelessness. That issue hasn't gone away. I mean, it's amazing how many people are still living on the streets. We have simply, in a sense, forgotten about the issues of society. I was in Richmond visiting my daughter a couple of weeks ago. There are a lot of people living on the streets of Richmond, maybe because it's easier to live there because it's a little warmer, but the numbers of people were really surprising. It's really a huge problem. So this demonstration that took place in the Rotunda was 20 years ago at least. And you know, where are we on that issue? So let me say something about the camping. People I know were interested in camping on the ground. This has been an issue that has come up in many of the Occupy demonstrations around the country. I think your lawyer has made an argument about next best thing to camping. You know that camping itself is prohibited on the Capitol grounds. And this is true, I have to say, in most parks. Forget the First Amendment for a moment. Just think about yourself as a user of the park. You go to the park with your kids, maybe you have some fun, and then all of a sudden, you know, the park's occupied by people who don't want to go to the public places where, or KOA or other places, and they're camped there, and there's no facilities, and all of a sudden the park turns into something else. I mean, I don't think there's much dispute about the fact that you can't just have people camping any place, because most places are not designed to accommodate people who are camping. What do you do with waste, as an example? It's just that's a serious problem. Now, what has the Supreme Court said about state capitol grounds? What has it said about camping? Well, there have been only really two cases. One was a case during post-dating the civil rights movement. It was a case from Washington. Well, actually, the first case was a civil rights demonstration. It's 1963, right in the middle of the civil rights demonstration. Citizens in South Carolina went to the Capitol. They engaged in a peaceful demonstration in which they basically were protesting what they believe to be discriminatory practices of the South Carolina State Assembly. There were some counter-demonstrators. Eventually, the cops arrested the people, told them they had to leave, and if they didn't leave, they would be arrested. This is how this plays out. So they tell you to leave, and you don't leave. Then they arrest you, and then you have to challenge. If you're fortunate to have a lawyer or speak for yourself, you have to challenge that arrest on the grounds that you were engaged in something that cannot lead to your arrest. And that was the argument that these people made it and lost, made it and lost, made it and lost. Eventually, they got to the Supreme Court, and the Supreme Court stated this was a case